the first to know in Nsem-Pii TV.
Now, Chief Justice, Her Ladyship Justice Gertrude Tukonu, on the 1st of September, and His Excellency John Dramani Mahama Dibetudwa said the Chief Justice has been dismissed. Na inyinasono a report submitted by a 5-member committee of inquiry headed by Justice Gabriel Scott Pwamang. Now, after the dismissal, Nsem-Pii and nipa hodo ediabetudwa, including former chief justices of this country, Ibini Mahama Sofia Akufo and Omoka Kahon, former attorney general ni Ayikwe Otu, and so am I a hint say dismissal na akosono, it is not going to be the end. It's not going to be the end. They are going to still proceed to the court to challenge the dismissal of the former Chief Justice. Yeka say, the Africa Confidential magazine, reporting for Africa since 1960, the 11th of September 2025 edition, Edin Sembia Betuja, Omohead Namodiato say, constitutional battles to follow Mahama's removal of Chief Justice. Almost say, the president's dismissal of Gertrude Tukonu raises more questions about the independent institutions and executive power. The fight over President John Dramani Mahama's dismissal of Chief Justice Gertrude Tukonu on 1st September has prompted calls for constitutional reform across the political spectrum. Concerns are mounting over judicial ethics and the independence, as well as the lack of checks on presidential authority. Checks by the African Confidential magazine by some of our well-known journalists have revealed that Ghana's former Attorney General under President John Ajay Kufuor's administration, Ni Ayikwe Otu, has hinted that further legal actions will be taken against the president on the dismissal of Chief Justice Gertrude Tukonu. What is more revealing is the fact that the former Attorney General and Minister of Justice also revealed that the committee head, Justice Gabriel Pwamang, was also a member of the same Judicial Council that is tasked to control the travel and other incentives of Chief Justices of Ghana. So, what is going to be more interesting when the ECOWAS court sits on this case is how a committee head of a committee that is supposed to inquire into the Chief Justice's spending can also be the same person that is found in the Judicial Council that is responsible for oversight responsibility on matters such as the travels of the Chief Justice. Interesting times ahead. Into the African Confidential magazine, can say, Omo anya hint to say more legal actions ebekoso efa the dismissal of Mahama Tukonu. And the African Confidential magazine can say, Omo journalists ati bibi sa edie free. Yewra ni Ayikwe Otu ya oye former minister or attorney general and minister of justice under the former president Kufuor's administration. Eno mu chire mu say yewra ni Ayikwe Otu aka ne baby say yewra Justice Gabriel Scott Pwamang ya ono na that committee of inquiry anoa omohwehwe Chief Justice Gertrude Tukonu nsemu edi report koma mampanyini ma yeyi na di no ebra na Judicial Council ya omo na ekura oversight responsibility Chief Justice na kwantuo sika ye de ma no pedam ye de ma no ya committee ni gina so titiriw ede epamo ya mame Gertrude Tukonu no. According to the African Confidential magazine, yewra Ayikwe Otu akoka ne baby say yewra Gabriel Scott Pwamang no that committee na no a omo ye hwehwemu ede epamo Chief Justice Stephen Konyaso. Sa Judicial Council no na osan wo so bi enti waka omo approve those travels and those per diems Edema, Yamame get to Kono, ya nay or more the same approval so, Eddie in the Africans. According to the African Confidential magazine, say and someone former Attorney General and Minister of Justice, ye Papa Ayikwe Otu Air Kano, say sanity then it is going to set the grounds for a wonderful state law proceedings the ECOWAS court. Now, menya an audio. Yeah, Papa Ayikwe Otu in some African Confidential magazine can or did to ja news file Jumedi so bra na wane something ladi ayineni ADM komo me the audio no ebeta to the amount no hu no sanche mu a yewra Ayikwe Otu di maye na the African Confidential magazine gina so aka say ebema in fact ECOWAS court etrasa so a ebema eho ayede.
They talk about audit or observation or something.
All right.
This is what happened, and the report is there. So where is this thing coming from?
Right. So let's put the committee in perspective. From the letter to the Chief Justice, which said, in the opinion of the committee, quote, in the opinion of the committee, the travel expenses which the Chief Justice heaped on the judicial service when she traveled on holidays in September 2023, first to Tanzania with her husband and second to the United States of America with her daughter, together with the payment of per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. Lawful, it is also unconstitutional. You are saying once the auditor didn't make any such claims, a committee like this cannot be heard to say what they said?
Please don't trivialize it. One of the members of the Judicial Council happened to be Gabriel Scott Pwamang. He had always been there with them, taking all the decisions, including travel policy. I explained the last time I was here that because of the judicial independence, they also granted them financial independence and asked them to work according to what they think is best to secure their independence. And therefore, they told them that it is only the Judicial Council that can determine anything which is pertaining to them, and not necessarily the executive. Not necessarily the executive. So the travel policy was something that came out from the Judicial Council where Pwamang has been serving. And he knows that there was this travel policy which allows the Chief Justice to travel with a person of her own choice, and that whatever, whatever per diem is given to her, the person he's traveling with will be given half. These are not stories. They are all there. The Chief Justice's appointment letter stated clearly that she will be entitled to 2 vacations in a year. And she can choose wherever she wants to go. Her duty is to tell them that this is vacation period, I intend to travel. Then the spending officers will work, buy the ticket, do all the protocols, and then give her whatever her entitlements are. And then she uses that to travel. I am challenging them. Let anybody bring a document where the Judicial Service or Secretary said, these are your entitlements. And then the Chief Justice said, no, I will not accept it. Give me this rather. Nothing of the sort happened. And I'm saying I've gone through it twice as a Minister of Justice and Attorney General and as a High Commissioner. When I'm to travel, I don't get involved. All I tell them is that I need to travel. They work it and bring it to me. Which is why you have a spending officer who is held liable. How did they change it? With Domelevo sitting there, now saying that she being the overall head. Where has it happened before? That the President of the Republic is being held responsible for the acts of the chief directors of the various ministries because he's the overall executive. Where has it happened before?
The central point that was raised by the petitioner is that in that travel policy, it provides a limit. And it says with an emphasis that the CJ can travel with the security alone. For a foreign travel, the security alone. Then they even impeach the policy by saying that as an Article 71 office holder, it is the president, or is it the other way? No, when committees are set up to determine emoluments, yes. It is the committee set up under Article 71 that determines what you are entitled to. Yeah. And anything beyond that is unconstitutional, is unlawful. Yeah. And then they quote the CJ herself in at least 2 or 3 different cases where she insists that anything beyond what has been determined by the president or parliament, president for parliament, parliament for president, and so on, is unconstitutional. And it is the reason when Abronye took the case to the Supreme Court about the spouses of presidents and vice presidents getting paid as ministers, the CJ led in that decision and said, you won't even allow, even if Parliament was approving it that way, it will not be allowed. You don't agree with them that you can't fault the committee on this?
We fault the committee that Chuchiketa brought a document on travel policy and per diems. In that travel policy, they said the people should be public officers. Then there was a footnote in which they stated that these things we have brought do not affect the judiciary because they are an independent body. He brought it and we pointed that out to him. They were all sitting in the committee, we tendered it. Okay. In fact, we allowed it to be tendered and brought it out to show them that it does not apply to the judiciary. Yeah. They stated clearly that their terms and conditions and all those purposes of office should be determined by the council. And I'm saying Pwamang was a member of the council. Now, if you followed the program as you had told us, I did mention that Oliver Vomawor's group were the next that we were to take. That is what they call the shining stars or so. Now, on that day, they wrote a letter to say that they would not be available because Oliver himself, according to him, was having medical issues, and some of his people who would testify were equally having medical issues. So they wanted a very long adjournment. The committee therefore adjourned the case to the 15th, the hearing to the 15th of September for us to come and start. On the same day, we made it clear to them, that is the day before we had written to say that they gave us only about 5 days and that we needed a little more time, 1 week to run up. We had even raised the issue that asking both parties to file their addresses simultaneously was not the best in view of the fact that there were petitioners who are alleging wrongdoing on the part of the Chief Justice, and therefore they should have the option to tell us how they have seen this thing right from the beginning for us to respond. The committee said, no, we should still keep to what they have said. And then they told us that, look, after all, if they ask us to file it by a certain date and we have not finished, we could file it within a reasonable time. It's not by force that we should meet it by all means, but we should file it within a reasonable time. That was 25th or so. That was when we were talking. So we took the 1 week and we were about to file it on the following Monday, only to be told that the report had already been issued. If you followed me on the PM Express, I also made the point that I didn't know that Chachu and his people had even filed their submissions because we were not served. It is this morning that you started reading from it that I was taken aback and said, what is happening? You even have a copy of what they filed. So, like I said, where is the fairness? They didn't even wait for us to file whatever. They did not say that if you don't file it by a certain date, we will take it that you are no longer interested in filing. But they just went ahead, apparently having prepared whatever they wanted to prepare, and went and submitted it based upon one-sided, submission. From what you are telling me now, these were the things that Chachu told them. What about our side?
So
they didn't want to hear what we wanted to say.
Okay, so let's get to learn about the facts. You were giving the 25th of August.
That is 5 days.
To file your written submissions, right?
Yes, yes.
By 25th, you had not filed.
We had not, because we were preparing to start the Shining Stars 2 at the same time.
But the petitioner, as in Daniel Ofori and his lawyers, had filed by 25th.
Nobody told us anything. Nobody. That's what I'm saying. I'm hearing it from you for the first time, because they told us we could file it within a reasonable time.
But you were giving 25th.
Adjourned the hearings to the 15th of September.
But you had just confirmed to me a while ago that you were giving the 25th to file.
Have I denied that?
Right. So as
we were giving.
Okay,
please,
I'm informing you.
I don't want this kind
No,
of.
we are doing just a bit of a fact.
Creating the impression as if I'm telling lies.
No, I'm not suggesting. I wouldn't do that. I wouldn't do that, sir. So I'm saying that on the 25th, the petitioner had filed their written submissions. They filed it on the 25th because that was the deadline you were giving, but you were unable to meet the deadline.
I'm saying to you that they said we should file it by the 25th. 24th, we wrote to them that we were on it, we would not be able to complete, and we needed 1 week.
Okay.
That was the day that Oliver Vomawo's group were also to start theirs. And we said, look, we are settled with 2 of them. One to write the submission, at the same time prepared to come and meet the Oliver Vomawa people, Shining Stars. So could we be giving 1 week to organize ourselves, file the written submission, and then start the hearing?
Okay.
And they told us that day, because it did not involve Chachuchikata and his group, they were not there. So what they would tell us is that they would give us an advice that we should try and file it within a reasonable period. That is all.
Okay.
And then the entire trial was then adjourned to the 15th to give Shining Stars, their lawyer, and whoever will come sufficient time to come back. What is today's date?
Right. So as I understand, you also were surprised that the committee had come up with a report on one petition when your expectation was that they will wait for the whole, all the petitions to be gone into before they present, as it were, a composite and one address or one report.
Oliver Vomawa was there on the first day when they tried to agree on the procedures they were going to adopt. And he would tell you that what they said was that they had 3 petitions. They would start with Daniel Ofori and adjourn the 2 Sanadai. When they are ready, they will call us, give us hearing notices to come, and then we go on with the other ones. So they were only going to start with Daniel Ofori. In the course of time, we received a hearing notice to appear to talk about issues being raised by Shining Stars. And I raised the objection that we are not finished with one, which you said you wanted to do. Why are you now moving on to deal with this one? He said, oh, these are just preliminary matters because they have indicated they wanted to call so many people, to subpoena so many people, and they wanted to talk to them to let them know how these subpoenas are done. Ask him, he was there with us, for example, that day. He had not always been with us because we have only been with Daniel Ofori. So he was there the first day. Then he came again for these preliminary matters to be dealt with, and that was it. I don't remember that he sat through and he can tell you what took place. I sat through and started the cross-examination from day one in December. On the Wednesday of May or so.
When you were agreeing on the procedure to be adopted, where the committee announced to you that they were going to use the CI 47, the High Court rules, they were going to use the High Court rules, as it were, and adopt it, and the High Court rules, and with necessary modifications where necessary. They had also announced to you, as in all of you, the lawyers and the parties in the room, that, quote, the trial will be petition by petition. Each of the three will be tried separately, end quote. Is that what you were told?
I wasn't there on the first day. It was my colleague Edu Kusi, who was present. But I read the proceedings for that day.
Okay.
And I'm saying that they told them that if you have a copy, read the entire thing and see whether you will not find them saying that they are going to adjourn the two Sanadai and call us when they are ready. Find out whether it was not agreed upon on that first day.
All right.